Justice Scalia hasn't been gone a year. I will just preface my remarks by one of my favorite quotes dealing with the subject that you just spoke upon. It's Judge Andrew Kleinfeld of the Ninth Circuit Court of Appeals in his dissent in the Compassion in Dying versus State of Washington case. He said that a question is important does not imply that it is constitutional. The Founding Fathers did not establish the United States as a democratic republic so that elected officials would decide trivia while all the great questions would be decided by the judiciary. That an issue is important does not mean that the people, through the democratically elected representatives, do not have the power to decide it. One might suppose that the general rule in a democratic republic would be the opposite with a few exceptions. Another point of view. Okay, I stand before you not as an academic. I'm not a social scientist. I am not a political scientist, nor a law professor. I am merely a practitioner of the arts. I always wondered why you say practice the law. Maybe it's because we never get it done perfectly. I'm a practitioner of the arts of law, politics, and governance. So I was involved in 22 elections for Congress, 4 for Attorney General, and 2 for governor, that is including primaries and generals. My record was 25-3. Unfortunately, the press just remembers the 3. So what is the relationship between the stewardship of knowledge and evangelization in my fields of endeavor? I think to understand my perspective, perhaps it is fitting for a quick review of my education and formation. I went to Catholic school my entire life. Catholic grade school, St. Barnabas in Long Beach, Catholic high school, St. Anthony's in Long Beach, University of Notre Dame. Took a sidelight to USC, which I guess Kevin Starr thinks is the largest Catholic school in America. And then I went to Georgetown. So I did get Catholic education, and then I went to a Jesuit school for law school. I learned my values and the tenets of my Catholic faith from my family and from my schooling. I learned that my life was not to be compartmentalized, but that I had to understand that I lived life as a unified living of life. They brought into clear view the fact that my faith was to animate my life with all my failings and shortcomings. So as that as a background, how do you express that, or how do you live that in the chosen professions of law, politics, and governance? Well, perhaps most importantly, you live that by the little things you do, by the everyday things you do. And we're reminded of that from time to time when people will come up to you and remind you of something you said that you'd forgotten a long time ago, or the way you acted towards them when they were an employee or a neighbor. And perhaps the greatest compliment is when someone says, we saw how you raised your children. We've been trying to do it that same way. Or the way that you treated your employees. Things that you never thought of, but things that were animated by the faith that you were taught and the faith that you attempted to live. In fact, it's sometimes shocking to realize how people pay attention to you. And I often repeat the story that Ron told me, Ron Austin, about one of the experiences that impacted his life and, in fact, led him on his road to conversion when he was a screenwriter in Hollywood, and he walked for lunchtime, I guess it was up in Sunset or wherever it was, and he came upon a scene of someone who had committed suicide by jumping off the top of a building, and his body was laying there with something over it, and he said there were caustic remarks made by the in crowd. Must have been a screenwriter, And he said as he walked by, he saw two Hispanic workers who stopped for a moment and each made the sign of the cross and then went on. And Ron has told me this many times. He said that impacted him because he said they have something I don't have. And so in many ways, it's the small things you do, the everyday things you do, the things when you are not consciously working out your faith that have perhaps the greatest impact. But I was thinking about this the other day when I happened to see some comments made by a formidable political figure these days, who in referring to members of the other party complained that they wear their religion on their sleeve. She went on to say that her opponents, and if I were still in the Congress, I would have been one of them, pray in church on Sunday, but then prey on the people the rest of the week. Somewhat of a difficult personal attack on a group. But I wondered as I pondered that, what does that mean? Was that meant to suggest that if someone brings their faith to the job of governing, that they will be met with the argument that they are parading around with religion on their sleeve? And is it an argument that those of faith can practice their faith anywhere except if they happen to be in a political office? Or does it mean that they ought to be disqualified from serving in public office because they bring their faith as part of who and what they are? You see, one of the other speakers mentioned earlier that the definition of a secular society is one in which it is more difficult to believe in God than not believe in God. And if that, in fact, is an appropriate observation of where we find ourselves, perhaps the idea that someone wears their religion on their sleeve is evidence of that. I would hope that I work to try and wear my religion in my heart and work out my job, whatever my job is, in the best way that I can. So, if you were running for office, what is your obligation? To hide your faith? To put it on your sleeve? What is it? It seems to me my obligation when I ran for office was to inform my constituents who and what I was, who and what I am. Sure, inform them of my political philosophy. Certainly, be open about what my positions are on current or foreseeable issues, but I also felt I have an obligation to inform my constituents or my prospective constituents as to my values and my core beliefs. Again, not wearing it on my sleeve, but I owed it to them so that when they made judgments, they would not feel that they were in some ways fooled by who I was when I was engaged in political discussion. So, when we talk about stewardship of knowledge and evangelization in present-day politics, what does that mean? Let me give you a few examples. Let me talk about primarily the social issues because that's where it comes into play most often. And I remember on more than one occasion when I have been involved in the discussion and the issue of abortion came up and someone would say to me or to others with whom I shared the same faith, "Oh, you're Catholic." Like, you're Catholic, so we know what you mean. Now, in one sense, that might be a compliment. You're a Catholic. You're faithful to your beliefs, so we know what you mean. But more often it was, "Oh, you're Catholic, so we know what you mean, and that doesn't count." Because you can't bring that into the discussion because then you are imposing your ideas on us. See, the secret in the secular society is that the imposition of the secular religion is okay. But should you trespass upon that, you are the outsider looking in, and somehow you have trespassed on rights. Oh, I just remember, and I think I've mentioned this here before, one of the great quotes from my friend Henry Hyde, a great congressman from from Illinois and a great defender of the unborn. He said, "I know someone who is so tolerant of other people's views that he will not impose his most deeply held views on himself." And it's funny, but isn't that what they're telling you to do? Don't impose it on, but don't even impose it on yourself, and don't express it. You might persuade someone to your point of view, and that is somehow improper in this secular society. So let me just go through quickly several issues that I had to deal with when I was in elected office and how I had to deal with it as someone who was informed as a Catholic. Meaning that I thought my decisions were informed by my Catholic faith, but I was also consistent with my obligations to defend the law, to carry out the law, to form the law. The death penalty. I was Attorney General of the state of California, where we executed the first person in 26 years while I was Attorney General, responsible for leading the arguments before the courts. As someone growing up in Catholic school, I had been informed on the death penalty and the teachings of the church on the death penalty, and frankly, as I was growing up, the death penalty was supported by the church on a number of different arguments. And I studied those arguments, and I understood those arguments. And in many ways, it was an extension of the right of self-defense and the obligation of a society to defend itself. Pope John Paul II led what I would consider a change of somewhat in the church on that. If you look at the writings of the church, and if you look at the Catholic Catechism, it circumscribes the circumstances under which the death penalty can be used, essentially to those in which no bloodless alternative is available. As a Catholic, I looked at that, and I wrestled with that, and I considered that, and came to the conclusion that as an example of prudential judgment, it was my best judgment based on everything I knew as the top law enforcement officer of the state of California, that in fact there were not alternatives that were bloodless to the carrying out of executions in the state of California for the small number of individuals for whom the death penalty had been established by a jury and affirmed by a judge and affirmed by the appellate courts of California and the Supreme Court by way of writ of certiorari. And yet, it was a difficult question for me. But once I resolved that question in my own mind, I thought, a lot of people, a disproportionate number of individuals who serve in law enforcement in California and throughout the country are Catholic. A disproportionate number of those who are our prison guards in our prison system are Catholic. And in most cases, it is likely that those who actually have to carry out the death penalty are Catholic. And I thought my church did very little in trying to explain to them that this was an area of prudential judgment, that yes, was a weighty matter, but that, as I have seen in other writings of the bishops, in areas of specific expertise, Catholic lay people are to be given, in some cases, the premium position of decision-making over others. And I had always found out that, at least my observation was, that seldom did the church fathers ever talk with those in law enforcement about what their judgments were with respect to bloodless alternatives. And so I felt there was an obligation to try and help in that regard. In another specific instance I had, the Congress, in the time that I was not in the Congress, when I was Attorney General and then for several years thereafter, and then I returned to the Congress, had passed the Defense of Marriage Act called DOMA. And it was a piece of legislation passed by the Congress, signed by President Clinton, and then it came under attack in the federal courts. Interestingly enough, when it came under federal attack, a new administration had taken office, actually two had gone, and the new administration decided that they would not defend it. And so, as the chairman of the House Administration Committee in the House of Representatives, I was responsible for following through on our responsibility of hiring counsel to defend that case before the courts. Problem is, the courts later said we had no standing to defend it. Only the federal government had the standing to defend it. Also, you remember here in the state of California, when the proposition was passed with respect to that matter, the Attorney General at the time, now the governor, originally announced that despite his problems with that law, he was going to defend it. Then he woke up one morning and said he had had a sudden inspiration that gave him problems with the law and that he would now attack the law in court. And it was then presented in court, and as was mentioned, it lost in court. And it was another example of what Judge Kleinfeld had said about that's not a trivial matter, that's an important matter, and the people of the state of California had spoken, and yet here in the state of California, the California Supreme Court decided that otherwise. But perhaps the case that I most recall well when I was Attorney General is a case called American Academy of Pediatrics versus Lundgren. This is a case involving a law that was passed that created a requirement for parental consent for minors who would otherwise seek abortions. And you may recall that ultimately we lost that case. That had remained dormant for some period of time when I became Attorney General. It had not really been pursued in terms of defense by the previous holder of that office. And so when we took over, we decided it was a properly passed law. I happen to agree with the law, both as someone who was a father and someone who understood parental rights, I thought, in this country. In this state, for instance, you cannot, at least it used to be the case, I think it still is, if you're under 16, you cannot go to a tanning studio to get tanned without the express permission of your parents. But if you're a child much below that, you can still go to a clinic at school that doesn't inform your parents to get an abortion. Interestingly, in that particular case, you know, there are 7 people on the California Supreme Court, and one of the crucial people on that panel at the time was the longest-serving member of the California Supreme Court in history named Stanley Mosk. He was a former Attorney General. He was known as a liberal Democrat and recognized as a civil rights supporter in the early years, and someone who actually was open to discussion. And when I was talking with our staff as we were preparing for the argument before the court, I said, you know what we ought to do here is argue from the standpoint of the parent, because he was not only a parent but a grandparent, and I knew he had a special relationship with his family. We argued that case before the California Supreme Court, and we won 4-3, with Stanley Mosk writing the opinion. But before that decision became final, we had a stepping down on the Supreme Court. Stanley Mosk stepped down, and he was replaced by a new appointee of Pat Brown, so they asked for a reconsideration. Now, I had great hopes because the new member of the panel was Catholic and had been educated in Catholic school, but he voted for reconsideration and then ultimately voted in the opposite direction. And so inside of 6 weeks, we went from winning that case to losing that case, and now that case is stood up as one of the great examples in the United States as to why parents have no right to know if their child is contemplating and actually receiving an abortion. Obviously, I was defending a law that was passed by the state of California. It was passed appropriately. My obligation, I thought, as Attorney General of the state of California was to defend the law unless I could find no constitutional basis upon which it could be defended, even if I were to disagree with it, because the people had the right to be defended in court. But beyond that, I felt very strongly on that and worked very hard on it from a personal basis because I thought it was an extension of the argument of the worth of an individual that I believe in, but had probably first been inculcated in my belief system through my parents and through the education I got in my Catholic schools. When I was a kid growing up, I never thought there would be a conflict between being a Catholic and being a loyal member of American society, and have it suggested that if I were to be an elected official, I would have to somehow hide my faith, not under a bushel basket, but hide my faith entirely. Thank you.